Excuse me, I want this menu item, but I want a special order. Do you do special orders? I'm sorry, ma'am. You're going to have to ask my financier if the terms of my debt repayment allow for me to do special orders. Findings, conclusions, and recommendation of the United States Magistrate Judge. Pursuant to 28 U.S.C. Section 636B and Special Order 3, this case was referred to the United States Magistrate Judge for case management, including the issuance of findings and a recommended disposition. Upon review of the relevant pleadings and applicable law, this case should be dismissed without prejudice for lack of jurisdiction. Background. Plaintiff Charity Colleen Krause, a resident of Dallas, Texas, filed a pro se complaint against defendant Neuropsychiatric Center et al. Wrong. It was not a pro se complaint. I did request to be considered pro hoc vis. A. B. It was not a complaint. It was a request for new trial. Doc 3 at 1. The complaint alleges only, please see attached, leave to file motion for new trial per Rule 59AB of Federal Rules of Civil Procedure. That's a quote. Doc 3 at 1. It includes a pleading titled, leave to file a motion for new trial that bears the style of a case previously dismissed by the United States Court District for the Southern District of Texas for one of jurisdiction, to wit, Krause versus Neuropsychiatric Center et al. Number 4:717-CV-02955, Southern District, Texas, Houston Division, October 4th, 2017. Wrong. It is not style of a case previously dismissed. If you read the motion for the new trial, it describes how there were two case numbers assigned to the same case, and only one of them was even acknowledged by the case, while the docket reflects that there was a conference call set up for several months later that was never canceled. Doc 3 at 2-4. Krause apparently requests this court to reconsider the dismissal for Southern District of Texas case and grant a new trial because of, quote, numerous constitutional and procedural violations, including potential abuses of Rule 23.1 FRCP regarding derivative action, end quote. Doc 3 at 4. That's correct. 2. Analysis. Pause. Derivative action. They did not consider this to be actually for evaluation under the due process in the judicial branch. They made this case management for a magistrate judge, leading me to believe that what they were really doing was a setup for what I had to appeal later regarding an other case that I understand now was part of why they detained me, concerning a Ramirez versus the Board of Medical Examiners. The year, apparently, the Board of Medical Examiners became the Texas Medical Board. So they could use me as a bridge between the revision of the nomenclature of the commission while it was under review by the Sunset Commission. Analysis and pause. The court should always examine sua sponte, if necessary, the threshold question of whether it has subject matter jurisdiction. System Pipe and Supply, Inc. versus MV Victor Kronatowski, 242 F.3D 322, 324, Fifth Circuit, 2001. Federal Rules Civil Procedure 12H3, quote, if the court determines at any time that it lacks subject matter jurisdiction, the court must dismiss the action. Even under the most liberal construction, however, Krause has not alleged facts that establish federal question or diversity jurisdiction in this court. Footnote. See Erickson versus Pardue, 551 U.S. 8994, 2007. pro se pleadings are to be liberally construed and held to less stringent standards than formal pleadings drafted by lawyers. CF Fed R Civ 8 P8E. Pleadings must be construed so as to do justice. Less stringent standards? So, in other words, don't even give the bitch a day in court. Send her back to the psych ward. No. No. It's not even a psych ward anymore. It's a terrorist recruitment center. Ma'am, the federal jurisdiction was a chance for you to show that you actually could handle and be competent in the face of charges of this profundity. But instead, you put yourself in the role of a magistrate judge for a mental health proceeding. That was actually an attempt to try to extort people into cooperation with acts of domestic and international terrorism, as has been proven since you signed this on September 26, 2019. I am saying that you guys manipulated your office as judges in order to set up fake filings with benchmark dates to finance acts of domestic and international terrorism. And you wouldn't stop.